I have read this case any number of times and I still can't work out how the practitioner thought this was okay. Johns was a sole practitioner in the 1970s. It's often easy to forget that every law firm, including sole practices, every law firm is a business. And as such, they face all the usual challenges that any other small business faces, including the challenge of maintaining sufficient cash flow to keep the bills paid. I'm guessing that was the reason for Mr. John's very unusual trust accounting arrangements. You see, every firm's general trust account is one big account holding the funds of many clients. Every firm maintains separate ledgers within that trust account, recording how much money each client has in the trust account. Mr. Johns also had within the trust account a ledger card that belonged to the firm. Once a week, he moved money from each client's ledger card to the firm's ledger card, still within the trust account, and then he withdrew that money from the trust account. All this was done without any client authority and without even telling the clients. At the end of each month, he would balance it all out and report monthly figures to the clients. Essentially, he was helping himself to client money ahead of time, hoping nobody would know. Unfortunately, he then let all of his accounting books fall into an absolute mess. When the trust account had its annual examination, the auditor realised what had been going on and reported the practitioner to the Law Society. They recommended that the practitioner be struck off, and ultimately the court agreed. President Moffat of the Court of Appeal said, "If a solicitor is entitled to receive money of the client in the solicitor's trust account to meet costs owing by the client to the solicitor, the proper course is to separate what is to become the solicitor's money from trust monies by a withdrawal of the money from the trust account and by payment of the cheque to the solicitor's general account. Only by this method will there be, as at that date, a notorious act which separates the trust money and the personal money of the solicitor. From this case, we confirm that office money and trust money must never mix, and firms can only pay themselves from the trust if they have clear instructions and make the transactions clearly accountable."